Hello, welcome to the Touro Law Review Podcast. It comes to us courtesy of the Touro College Jacob D. Fuchsberg Law Center and the Touro Law Review. Our topic for today is cancel culture and the First Amendment. Our invited guest is Professor Alan Dershowitz. Professor Dershowitz is a professor at Harvard Law School, an attorney, a prolific author. Our panelists from Touro are Professor Jorge Roig, who teaches constitutional law, and Georgia Reid, a third-year law student and editor of the online Law Review. I'm Professor Peter Zablotsky, the moderator. Welcome to all. Professor Dershowitz, if we can begin with you, you've written and spoken extensively on this topic. So perhaps you'll start us off by defining cancel culture as is relevant to your views, and then expounding on your views of the First Amendment and how it relates to your definition of cancel culture.
Well, thank you so much for inviting me. I follow very closely Touro College and the Touro Law School. It's been a great addition to legal education and to education in general. I go back to the founder of Touro College a long, long time ago, and so I'm a fan. The interesting thing about cancel culture itself is protected by the First Amendment. That is, people have the right to cancel other people under the First Amendment. Cancel culture, when done by private parties, when done by individuals, is as protected by the First Amendment as free speech or free press or the right to petition government. But even though it's protected by the Constitution, it's wrong. It's wrong for a lot of reasons. First, it is overbroad. It cancels people, not statements or acts. And almost anybody is cancelable. Dr. was canceled recently. Harry Potter has been canceled. If we back and read the writings of Dostoevsky, he would be canceled. T.S. Eliot would be canceled. Renoir's paintings, Picasso's, everybody is subject to cancellation. Obviously, Thomas Jefferson, Abraham Lincoln, many of them have already suffered from some degree of cancellation. Cancellation really finds its way back in history. My first encounters with cancellation came when I was a young high school and college student during McCarthyism, when people's whole lives and accomplishments were canceled if they were suspected of attending a single meeting of the Communist Party back in the 1930s when it was fighting fascism and when many Americans were canceled. It's interesting that people who joined the Fascist Party were not canceled. Only people who joined the Communist Party to fight the Nazi and the Fascist parties were canceled. There was, for example, a very, very large number of Americans who were fascists. Justice Scalia's father was a proud member of the New Jersey Fascist Party. Many Columbia University professors who were of Italian background joined La Casa Italiana, which was a fascist institution at Columbia. But the canceling all went one way. When we finished the Second World War and entered the Cold War, the cancellation all became people on the left. The irony is now cancel culture is a weapon of the left, being used against the liberals, moderates, centrists, and the right, and the extreme right. And of course, deep down, everybody wants to cancel somebody. Obviously, there's a Hebrew expression. When we, as you say the word Hitler, we always follow it with Yamach Shemo, which in Hebrew means may his name be canceled. Yamach Shemo, literally may his name be canceled. So we all want to cancel something. What's wrong with the cancel culture today in America is that it denies due process. It's over. There is no appellate remedy for it. It can be weaponized and used against one side rather than the other. And fundamentally, it not only denies the canceled person the right to speak, perform, but it denies the rest of us the right to be educated, the right to listen, the right to enjoy their music, the right to benefit from them. So it's a two-way street, and people should feel very ambivalent about it. I was a great fan, am a great fan of the Metropolitan Opera, and James Levine was my favorite conductor. And I was devastated when I found out about some of the accusations against him and that he was canceled by the Metropolitan Opera. Obviously, if the accusations were true, he deserves to be condemned and vilified if it's true, if these things are true. But do I deserve not to be able to listen to his music? Don't I have rights also? Don't I have rights to listen to Placido Domingo? Don't I have rights to go to a museum and look at Picasso and Renoir's paintings? So we're not only talking about the rights of people who have been canceled, but the rights of people who have been victimized by the cancellation, even though they have done nothing wrong. In the end, fundamentally, cancel culture is inconsistent with the spirit of the First Amendment, or protected itself by the First Amendment. That shouldn't be an irony. Communism is protected by the First Amendment. Fascism is protected by the First Amendment. All of them are inconsistent with the spirit of the First Amendment because they would deprive us of our basic fundamental rights. But the essence of a civil libertarian is one who defends the rights even of those who would take away our rights. You cannot live in a civil liberties society in which there is free speech for me, but not for thee, due process for me, but not for thee. We have to have a single standard. We have to have processes. It was Felix Frankfurter who once said, boring as it may sound, that the history of liberty is a history of process, a history of procedure, a history not of end results, but how we go about achieving end results. And cancel process suffers from all the vices of what tyrannical regimes do. Stalin understood cancel culture. I went to the Soviet Union in the 1970s with Telford Taylor, who had been the chief prosecutor at Nuremberg. One of the first things we did was go to the Nuremberg Museum. And we saw that Stalin had canceled Telford Taylor. He had been the American prosecutor, but when you looked at the pictures of the people at Nuremberg, there were empty spaces where people who had fallen out of favor with Stalin, where their pictures were. He understood how to cancel. And we are doing that today. And so cancel culture is in danger of becoming American culture. And if it ever becomes American culture, we have deep problems with our democracy.
Okay. Well, all right. We appreciate that to get us started. I had some questions perhaps about if the First Amendment is the doctrine only has a limited role as opposed to the spirit. But then we also speak about processes. I'm wondering what processes might be appropriate. But let me turn it to Professor Roig first to perhaps ask questions along those lines.
So I have similar questions for sure, but I want to get started with sort of backwards looking first for a minute, because I think you've already introduced, right, some historical comparisons. And, I thought all the way back to the ancient Greeks and their procedure for ostracism, public shaming during the Middle Ages, and, you mentioned Stalinism, McCarthyism, etc. What is different now? And perhaps you've already hinted when you talked about state action versus private action, right? What is the difference between what is happening now and what has happened throughout human history, in your view?
That's a great question. I think there are many differences. One of the main differences is that the shaming that existed previously in Jewish custom, it was called cherem. You were put in cherem. You were taken out of the community. Nobody was allowed to talk to you. Obviously, many religious groups have a similar approach. Most of those have applied to things that happen now. That is, you were shamed for what you did today. Cancel culture has no statute of limitations. It goes back 20 years, 30 years, 40 years, 50 years. What it is it's a process by which people can search for sin, can find out that you did something wrong many years ago. And if they disapprove of you today for political reasons, but can't cancel you for what you've done today, they go back and they find something to cancel you about. And they apply a standard that wasn't applicable at the time. Look, there's no justifying what some men did in relation to some women back in the day. The standards were different, and no one wants to excuse what went on back then. But to hold, Abraham Lincoln to today's standards of racial equality, to hold Thomas Jefferson to today's standards. Thomas Jefferson hated slavery. He would have liked to abolish it. He was a hypocrite. He, however, owned his own slaves. He didn't free them except for the Hemings family. But it's the standardlessness of cancel culture. It's the pervasiveness. It's how widely it's done, and the fact that there is no due process. Now, there are many kinds of issues. Let's talk about my case, because it's obviously something that concerns me. I've been canceled. The 92nd Street Y, where I appeared for 25 years as the second most popular speaker and most prominent speaker after Elie Wiesel, suddenly canceled me when I was accused of having sex with one of Jeffrey Epstein's underage women, a woman I never met, never heard of. There was absolutely no truth to the claim at all, and I disproved it unequivocally. I found emails from her in which she admitted she never met me, surreptitiously tape recorded her lawyer, where her lawyer, David Boies, acknowledged that I couldn't have been in the places she said I was, and said these words on the tape: "She's wrong, simply wrong," in accusing you. I had a former director of the FBI do a thorough investigation. So it was proved conclusively, without any doubt, that I had done absolutely nothing wrong. But the 92nd Street Y still canceled me. They said, "We know you did nothing wrong. We know you're innocent, but we don't want trouble. And we know that if you were to speak at the 92nd Street Y, there would be protests." And it's a perfect example, because there would have been. There would have been 25 people protesting outside. But in the meantime, 500 people who wanted to hear me were denied the right to hear me speak about my book, Defending Israel. And so I was deprived of the right to speak about Israel. 500 people were deprived of the right to hear me speak about it. Not 500, 5,000, because they would have done it on teleconferencing all around the country. All of those people were denied the right based on what they knew was a false accusation. The same thing was true with McCarthyism. There were many false accusations. Many of them were matters of degree. In my case, it wasn't even a matter of degree. I never met the woman, never heard of her, swore under oath I never did, and subjected myself to a perjury prosecution if I were lying. But nonetheless, I got canceled and I had nowhere to go. I wrote an op-ed for the Wall Street Journal demanding that the FBI investigate me. Who's ever heard of anybody demanding to be investigated by the FBI? I demanded to be investigated by the FBI. They wouldn't do it. I demanded that Harvard investigate me. They wouldn't do it. I called for a Me Too court where former judges, retired prominent people, you could go and bring your case to show you did nothing wrong. Today, you cannot prove your innocence. That's why I wrote a book called Guilt by Accusation, The Challenge of Proving Innocence in the Age of Me Too. So there are two issues. One, totally innocent people like me who have been caught up in the process and have no way of proving their innocence, totally innocent, not matters of degree, not issues like with Cuomo, did I touch her face, did I tell a bad joke? I have never, zero, ever done anything wrong in relation to a woman, period. Nobody could ever claim I did. So there are those cases where simply innocent people have a case made up against them. Then there are cases that are matters of degree, or which standards apply, Placido Domingo and James Levine. Those are matters of degree, and how you apply standards and ex post facto and all of that. So there are many, many such cases. But today, the difference is that it goes back in time with no statute of limitations. It's pervasive, and it's being used largely by one side of the political spectrum as a weapon against another side of the political spectrum.
Professor Roig, you have a follow-up? I mean, you said you wanted to perhaps ask a standards question, or...
Yeah, and I'll let Georgia afterwards, but I think it is a perfect segue to come back to what Professor Zablotsky was pointing at, and the standard, right? So, or the process. Is there a way in which you have thought this might be subject to some kind of process? How would you design some kind of system for sort of vetting these claims?
Well, we can have an informal court with former justices, Justice O'Connor, Justice Kennedy, Justice Souter, former judges, presidents of universities, retired CEOs of companies. Let there be some way where a falsely accused person can bring a challenge. Most people wouldn't bring challenges because they have something to hide, or it's a matter of degree. In my case, it was very simple. I have nothing to hide. I've touched one woman in my life since the day I met Jeffrey Epstein, my wife, and I've never done anything wrong. I never flirted, never touched anybody. 0, 0. So it's easy for me to bring that challenge. It's much harder when it's a matter of degree, and it's much harder when it goes back in time. Mine goes back in time 21 years. Some go back in time, or some people are dead. Take Shlomo Carlebach, the great Jewish musician whose Jewish liturgy appears throughout the world. He was first accused after he died. And he had no opportunity to defend himself, no process, and yet the Central Synagogue banned his music for a year. I don't know what they've done now, but he was canceled for at least a year without any process in place for being able to deny the allegations against him or put them in context. Al Franken had to leave the Senate for what? Things that amount to a 2 on a scale of 10. And it's so hard to know. Take, for example, current politics. President Biden, who I like and have known for years and have supported, was falsely accused of a very serious crime, a 9 on a scale of 10, by a woman named Reid. And turned out she had no credibility. But the charge was very, very serious. Cuomo, on the other hand, has been accused of 2s and 3s on a scale of 10 by women who seem to have quite a bit of credibility. So you have these differences. 1, the seriousness of the allegation. 2, the credibility of the accuser. 3, the timing. 4, perhaps the political motivation. We know in Cuomo's case, one of the accusers, somebody who's running for office, and she's running on this platform, which creates some doubts about her motive or credibility. So it's going to be very hard to come up with standards for this, but I think we need a process.
Ms. Reid, you have a question you'd like to ask from a student's perspective?
I do. I came prepared with a couple of questions about this topic as it relates to the law school experience, but I first want to say it's really an interesting concept to say, not only are you canceling the speaker or the artist or the performer, but you're canceling the audience that enjoys that speaker from ever hearing them perform or watching them act again. I can understand, private companies saying, listen, we don't like that you tweeted something racist, you're fired. But then when you take it to an extreme where there is no due process and someone's been canceled and you can't enjoy their performances or their lectures, that is something all too different, which I think is a very interesting concept. But I know you discuss sometimes on your podcast and in your books the weaponizing of the Constitution and the weaponizing of the law and getting canceled for representing the wrong client. And I just was wondering, from a student's perspective, since we are in a rather divisive country at the moment, or divided, I should say, when students come to law school, I think some people are either on the extreme left or the extreme right, and they come to law school with an agenda, with a purpose in mind to change things to fit their narrative. So what would you, as a lifelong professor, want to communicate to a student like that about how to study law and practice law? That's my question.
Well, first of all, I think the villains are often the deans and the professors. Pardon me for being so accusatory. I think, having taught 55 years and been in the public light almost 65 years, I have never met a less courageous group of people than tenured professors. They are terrified of their students. Many professors just want to give the students what the students want to hear, and student evaluations encourage that. And so, students confuse being kind of feeling good about themselves with learning. In 50 years of teaching at Harvard, I never expressed a personal view in the classroom. Students had no idea, unless they read my writings outside of class, what my views were on the death penalty, what my views were in Israel, what my views were as a Democrat or a Republican, because my goal was not to teach them what to think, it was to teach them how to think. And if you're going to teach students how to think, you have to be provocative and you have to challenge their views. And I think too few professors today are prepared to challenge their views because they're terrified. If you challenge the views of students, you will be ostracized, you will be canceled. We see that happening all the time. And so I'll give you an example. I have a friend, who's a professor of criminal law for many, many years, very distinguished professor. I won't mention him with the university. And he spent all summer a few years ago going through every criminal law casebook to find a criminal law casebook that didn't cover the subject of rape, because he didn't want to teach it as a white male, and he didn't want to skip it if it was in the book. So he finally found a book, a really horrible criminal law casebook. It was terrible in every respect, but it satisfied him because it never mentioned the word rape. So he could teach homicide, he could teach larceny, he could teach extortion, but he didn't have to not teach rape, and he didn't have to teach rape because he was terrified about what the reaction would be if he wanted to teach about it. I taught about it and always got lots of criticism because I was teaching students who would be appealing to jurors who would be very sexist. So I had to cover what the sexist arguments would be around the issue of rape, what jurors might think about dress for sex, about all of those kinds of absurd arguments, prior history, you had to address that. And as a Socratic professor, my job was always to play the devil's advocate. Every so often I got lucky and I had a student in my class like Ted Cruz. When I had Ted Cruz as my student, I didn't have to play the devil's advocate. He was the devil personified. He would make all the arguments on the extreme right, so I could not have to make those arguments. But when I didn't have a Ted Cruz in the class, I wasn't going to just let the leftist students or the centrist students or the liberal students, of which I was one, dominate the discussion. For example, I had to always argue in favor of the death penalty. I've devoted my whole life since I was like 12 years old to opposing the death penalty. I drafted the first Supreme Court decision against the death penalty. I wrote the first major law review article against the death penalty constitutionality. But in class, I defended the death penalty because no one else would. And I think today professors, not including the current professors on this program and some other good ones that I know of, are terrified to make devil's advocate positions for fear that they will be canceled and ostracized. And that's not good for anybody's education.
Well, I had Miss Reid as a student, so you could judge the level of fear that I may or may not feel. But I do want to give Miss Reid the chance to ask her follow-up question, because she said she had two, and we certainly want law students to have the benefit of some of this discussion. So, Ms. Reid, I'll invite you to ask your second question.
Oh, thank you. Yeah, and I do want to say that I think some students are also fearful of speaking up, and even just playing the devil's advocate, even just, arguing back and forth for the sake of figuring out the law and the philosophy. Some people are afraid. They're just afraid. So my next question is, if it was the first day for a law student in your First Amendment seminar, what is the bottom line? What doctrine would you want to make sure that students understand the most, either as it relates to free speech on campus or in cancel culture?
Okay, I think I would paraphrase Winston Churchill and basically say freedom of speech is the worst possible system, except for all the others that have been tried over time. I always ask for what's the alternative to open debate and freedom of speech. The alternative either has to be that you pick and choose what you censor, or you have total censorship or no censorship. There doesn't seem to be a middle ground that's acceptable, because we live in a world where we need ism equity. So if you allow women to tell you that you can't say certain things, then African Americans tell you you can't say certain things, then Jews tell you you can't say certain things, and Muslims tell you can't say certain things, and differently abled people tell you can't say certain things, and in the end you can't say anything. And so I always press students on what's the alternative to freedom of speech, the marketplace of ideas. What's the alternative to John Stuart Mill's approach to the open marketplace? Look, I don't think that Mill and Jefferson were necessarily empirically correct when they essentially argued that the truth will always emerge from the marketplace. That's not the case. The truth will sometimes lose. The marketplace of ideas is no guarantee, just like elections are no guarantee. Look, we elected Donald Trump. And whatever you might think, that was very surprising. would you say, as the result of that, if you're a liberal and thought it was a disaster to elect Donald Trump, would you ever say, let's end voting? No, of course not. Democracy doesn't produce guaranteed positive results. Free speech doesn't produce guaranteed positive results. But I always have to ask the question, what's the alternative? And, it was, I think, Bill Sapphire who put it very well when he said, in the United States, every American is entitled to complain about what's on television except Uncle Sam. He's the only American who can't complain because he's the government. And the Constitution says Congress will make no law abridging the freedom of speech. But now what we're seeing is large, big tech, which is almost as powerful in the government in some ways, picking and choosing what to allow on their platforms. We're seeing members of Congress threatening satellite providers and cable providers that unless they take Fox and Newsmax off the air, there might be consequences. And so it's become much more complicated. It's easy to defend free speech against the government. It's much harder to defend free speech against cancel culture, against big tech, against private universities. That's a much greater challenge. And so the spirit of the First Amendment is as important in today's society as the technical application of the First Amendment.
Professor Roig, we're circling back to the First Amendment. I invite you again to enter the discussion.
Thank you. Yeah, I was kind of smiling / chuckling a little bit because you kind of preempted what would have been my third question, which was, you took the words right out of my mouth with Winston Churchill, right? What's the alternative? And the other aspect of this is the state action thing that you were also bringing up, and the monopoly power of these companies, right? And I was wondering, I guess from my point of view, maybe what we need to reform isn't free speech doctrine, but rather antitrust doctrine, or tweak the state action exceptions or something like that. And I was wondering if you've given some thought to specific changes that might be merited in those parts of the law.
Yeah, no, I have. And antitrust is a blunderbuss instrument, and it equates, apples and oranges with free speech. You can't do that. There's a difference between regulating companies that sell a product and regulating companies that promote speech on the medium. There are things we can do. I don't think antitrust will do the job ultimately. The goal of antitrust is not to promote free speech. It is to promote the marketplace and included in the marketplace of ideas. But let's look at, for example, Section 230 of the Communications Decency Act, which gives exemptions to platforms like Twitter and Facebook and Google, gives them exemptions, not from antitrust laws, but from defamation laws on the theory that they're not publishers. The New York Times doesn't have exemptions. Fox doesn't have exemptions because they pick and choose. But the platforms were given exemptions on the assumption that they wouldn't pick and choose, that they're not responsible for what goes on the platform. And it's true that they don't prior censor. So I would keep the 230 exemption for anything that goes up on the website. But if they don't take it down within a certain period of time after receiving formal complaints, I would take away their 230 exemption if they pick and choose. So, for example, if they take down Trump, and again, I'm not a Trump supporter, I'm a liberal Democrat. I vote for liberal Democrats. I campaign for liberal Democrats. But if they take down Trump and they don't take down Ilhan Omar, who has made horrible racist, anti-Semitic, and bigoted statements, the problem with the social media is if they take down something saying it's not true, they create an implication that what they don't take down is true. And that's creating a false impression among the people. You can't do that. That's the problem with partial censorship. When you don't censor, you give the imprimatur. I'll tell a story I think will help illustrate that. I went to Madrid in the 1970s, along with Erwin Kotler. We were representing Soviet dissidents at the Helsinki meetings. And there were a series of debates between people from the West, Erwin and I, and communists, people from the Soviet Union. And one of the debates was about anti-Semitism. And in the course of the debate, I complained that the Soviet Union was encouraging and allowing anti-Semitism, and I produced a series of brochures and pamphlets which attacked Jews. The Soviet guy was very smart. He was prepared. He produced a series of worse pamphlets that attacked Jews published in America. And of course, by doing so, he fell right into my trap. Because the difference was this: the material that was produced in the Soviet Union that was anti-Semitic had a stamp approved by Glovlit, the Soviet censorship agency, whereas the much worse material published in the United States had a stamp approved by the Nazi Party of the United States, the white supremacist Nazi Ku Klux Klan. So one had the imprimatur of the government, the other didn't, because in the Soviet Union, there were only two kinds of things that could exist: material that was approved by the government or material that was censored by the government. No Soviet official ever said, "I disagree with your right to say this," quoting Voltaire, "but I will defend to the death your right to say it." No. If a Soviet person disagreed, or if a Chinese communist person today or a Cuban communist today disagrees with what you say, they won't defend your right to say it, they'll censor it. So there's an enormous difference between simply allowing things to go on the internet. Rumble does that. The taxi cab theory, anything goes, and saying, no, Trump comes down, Giuliani comes down, Ilhan Omar stays up, OAC stays up. We'll make choices. We'll pick and choose what we think is false and what we think is true. Once you do that, you're entering into the area where people will come to believe that what you don't censor has your imprimatur, and that's extraordinarily dangerous.
Yeah, let me just add, while we're on the subject of Section 230, that what you point out about the picking and choosing is a feature, not a bug of Section 230, right? Section 230 not only immunizes against what gets posted, but also immunizes the platform from what they take down. So the act of taking down is immune. And I think, and there was a reason for it, right? The idea was we wanted to encourage those platforms to filter out bad content. And initially it was all about copyright infringement, right? But
or pornography or things of that kind. But today, it's interesting because my reading of 230, maybe you have a different reading. I think that if Facebook takes down a post and says we're taking it down because it's false, I think they can be sued for defamation for that. In other words, I don't think 230 exempts them from their own defamatory statements against others. It exempts them from being sued for the defamation of things that are posted. But if Facebook defames or if YouTube defames, I don't think they get exemption under 230. It'd be interesting. I don't know of any such cases that have litigated that issue, but it's an interesting distinction.
Yes, no, and that's correct, right? If Facebook or any platform uses their editorial control, right, such that they are the creators of the defamatory statement, they certainly don't get immunity. The question I think you raise is, can the taking down by itself be defamatory? And I think that's a really interesting point.
Yeah, I think if it's done without comment, it would probably be covered by 230. If it's done and the implication is that it's taken down because it's false, it would be. I mean, there are so many interesting issues going on around now. For example, around transgender issues, there have been a series of books and articles that have been published critical of attempts to encourage people to transition. And they've been taken down as medically unsound. And again, what do you do with medically unsound information? What do you do with information that could really lead to increasing the dangers of the pandemic? I think there are a lot of things that can be done. First of all, I think the medical profession can do a lot more in regulating what doctors say on any medium. The FDA could probably do more on that. But if you have somebody debating the masks, I debated Bobby Kennedy on a platform on, he's not an anti-vaxxer, but he's a skeptic of vaccines. I am a pro-vaxxer, pro-mask, pro-social distance, pro-aggressive attempts to try to prevent the spread. And that's a fair debate to have. as long as nobody tells you to take a drug that might kill you, that becomes a much more difficult issue.
Well, what I find interesting, sort of sitting back and listening to this discussion, we sort of very quickly made the point that First Amendment doctrine was not going to really get us very far in terms of addressing this problem. And so then we discussed the spirit of the First Amendment, and then we've had to move completely off of the First Amendment and look for what you described as maybe some pretty blunt tools to, like, some sections of the antitrust law, for example. I guess my final question would be, if we're going to do that, if we have to move away from the First Amendment, is there anything in the First Amendment that's analogous in terms of trying to have some kind of standard, some kind of content neutral concept or whatever, that we could then apply via antitrust or, to tech company or the AMA through to doctors or something like that? I mean, is there an analogy to be drawn, or?
I think there is, yeah. Not the First Amendment itself in its words, but the First Amendment has been interpreted over and over again to preclude content censorship. You get justices as widely different as Rehnquist and Douglas saying that there's no such thing as a false idea under the First Amendment. And so you can express any idea you want. You can say the earth is flat. You can say the Holocaust didn't occur. You can make any absurd statements. Elvis Presley is alive and living in Tennessee. John F. Kennedy was not killed. You can say any of those things as long as you don't defame somebody or engage in other kind of criminal conduct. So I think that's one rule that should be applied. There's no such thing as a false idea. Now, the line between ideas and facts is difficult. I think the First Amendment also protects false facts, as long as they're not false facts about an individual person. We're different than Canada. In Canada, you can't say Jews are trying to control the world. In the United States, you can say Jews are trying to control the world. In both countries, you can't say that so-and-so Rothschild is trying to control the world, because he's an individual, even though he stands for the Jews who control the world. So we've drawn those distinctions. In Germany, you can't say the Holocaust occurred. Look at France and Turkey. It's so interesting. In Turkey, it's a crime. It's a crime to say that the Armenian genocide occurred. In France, it's a crime to say the Armenian genocide didn't occur. And now with the internet, you can't say anything just in Turkey and just in France, because everything you say in Turkey is broadcast in France. Everything you say in France is broadcast in Turkey, which really means you can't talk about the Armenian Holocaust or genocide. You can't talk about it, because whatever you say, you'll be committing a crime in one country or the other. And it does go across state lines. I was once indicted, literally indicted in Italy, because I condemned a Green Party judge who had issued an opinion saying that the terrorists who had killed a number of people were just freedom fighters and shouldn't be extradited or whatever. I don't remember the exact terms. And I wrote an op-ed from my office in Cambridge saying this was a Magna Carta for terrorism, and that the judge was a total ignoramus when it came to the causes of terrorism. The judge indicted me in Turin, Italy, for what I said in my office in Cambridge. And being a provocative person, I purposely, on my next trip to Italy, held a press conference, held my hands out, and said, please, I'm here. You have no excuse. Bring me to Turin, arrest me, put me on trial. I want to defend my free speech on the ground that what I said was true. Of course, they never did. I guess I'm still technically under indictment in Turin for having accused a judge of being writing a Magna Carta for terrorism. So the point, of course, is that there's no longer a territorial limitation on restrictions on free speech because of the internet. Whatever you say anywhere can be made a crime in other parts of the world and could be used to give you a red notice or not allow you to travel, although I doubt Interpol would enforce a red notice based on freedom of speech. But we live in a dangerous world at a dangerous time.
Well, I think it is incumbent on me to perform the the sad task of bringing this to a conclusion.
Oh, they didn't. I'm enjoying this so much. The questions have been great.
Well, then perhaps we'll have to do a part 2 as events unfold, and we can try again. I want to thank you all very much for participating, and I look forward to the next time if we're able to, lucky enough to be able to have one.
Thank you.
Thank you so much, Professor Dershowitz. It was great to see you again after 20 years.
Yeah. That's so nice to hear about my class. When you took it, was it with Steve Gould and Bob Nozick?
Yes.
They're both gone now, unfortunately. So I love that class.
I know you had a lot of fun in those lectures. One could tell.
Yeah. As I said, I don't know why anybody paid me for giving, for learning like that. I learned so much from my colleagues. It was great. Well, thanks, and good luck on your teaching and on the great college and law school. I was there at the beginning when Touro was founded, and in fact, the president of Touro at one point asked me if I'd be interested in coming on as dean, but I didn't want to do that. But it's become a great place, and of course, I knew Joseph Fuchsberg as well. So I feel a connection to the college and the law school.
Well, that's fine. And again, thank you very much.
Sir, thank you.
Bye.